'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure, Shaq.
If we've established that we actually have a contract, a simple apparent contract, because we've got those three elements of agreement, intent, consideration, and we've worked out that it's enforceable because we've got true consent, we had capacity, etc., then the next thing for us to understand is legally, what have we agreed to? Okay, what's in the deal? Because when we're in business, sometimes we can make statements, we can include things in the contract, and then things don't turn out how we want. People don't do what they do, what they've said they will, or perhaps we don't want to do what we've said we will. Are we legally obligated to do it, A, and B, what happens if we don't do it? So that's what this module's about, terms and remedies. So let's begin with an overview of this module, plus a little bit of terminology about terms, conditions, warranties, and why understanding this classification is important for contract law. The rights and obligations of the parties in a contract are called the terms. Right? Now, most times when you think of a written contract, those obligations and rights are written down, and it's easy to see what the term is. But sometimes terms can be stated, or they might even be implied. So it can be quite difficult to understand in some situations what the rights and obligations of the parties are. But any right and obligation is called a term. That's what you've agreed to. Okay. But these terms can be subdivided, right? There are two kinds of terms, conditions and warranties. Now, this can be a little confusing for people because when we hear particularly the term warranty colloquially, we kind of think you're going to an electrical retailer and you buy something like a TV and it has a warranty. Yeah, does that sound familiar? Yeah, it's not really about that. I mean, it's related, but really, like that industry and society has taken this legal word and turned it into something different, okay? When we're speaking legally about a warranty, we're speaking about a particular kind of term of a contract, okay? So let's hop in and have a look at the difference between a condition and a warranty. So just to reiterate, if we have the terms of a contract, which are our specific rights and obligations under the contract, then we're going to have some terms that are conditions and some that are warranties. Often, not always, sometimes they might all be conditions. But we're probably going to have some conditions and some warranties. Now, the conditions are important terms, okay? They're so important you wouldn't have entered the contract without them. A warranty is one of lesser importance, and the remedies vary whether you've breached a condition or a warranty. Now, how you work out, is a term a condition or is it a warranty? We look at the facts objectively, look at the conduct of the parties and the context, okay? And we're using these words with their legal meaning here, not their colloquial meaning. So a condition is so fundamentally important, you wouldn't have entered the contract without it. If you breach a condition, the other party can terminate the contract and get damages. Right? They can keep the contract on foot if they want to. They can say, yeah, we want to keep going and get damages. But a breach of condition allows you to get out of the contract. In contrast, a warranty is a term that you would have entered into the contract even without this warranty. If you breach a warranty, the injured party must still perform. So you can't get out of the contract if the other party breaches it. Okay? That's why it's so important to understand. Your remedy changes about whether it's a condition or a warranty. So we have two cases here. The case for condition is Associated Newspaper and Banks, and it was a case about cartoons, actually. I think there was a very famous cartoon called Ginger Meggs, and the cartoonist was deciding, which newspaper to put their cartoons in. And you might not remember, but newspapers used to have a supplement that you would pull out that had all the cartoons in it. Now, Associated Newspapers had said that they would put Ginger Meggs are on the front page of that lift out of the cartoons. And to banks, that was like really important because that gave more readership, more exposure, and it was something he wouldn't have. That was a deciding factor about entering the contract, is what the courts found. So when they didn't put Ginger Meggs on the front page, it was a breach of condition, and banks could actually get out of that contract. Now let's contrast this with Bettini and Guy. So Bettini was a tenor and had promised to perform for Guy. So there was a contract between B, the tenor, and Guy, who was going to get Bettini to actually perform. And the contract said that that Bettini must, without fail, turn up in London 6 days prior to the performance. Okay. And Bettini turned up 2 days prior. So the courts had to determine, was turning up 2 days prior to the performance a condition or a warranty? And in this case, the court said, look, if he hadn't have turned up to perform, that would have clearly been a breach of condition because that's what you were really kind of paying him to be able to do. Turning up in advance, 2 days versus 6 days, in this case, that was a warranty. Right? Because you would have got him in to perform even with fewer days to warm up is what they found. So therefore, this was a breach of warranty and Guy couldn't actually get out of the contract, okay, because it was a breach of warranty. It was a lesser condition. Guy would have entered the contract with Bettini with or without this 6 day prior. So there you have it. Terms are the rights and obligations of the parties within the contract. In a written contract, they're generally like written down and specified. We need to be able to distinguish a condition from a warranty because, very importantly, the remedies vary. If you breach a condition, you have the option of terminating the contract if you want. If you only breach a warranty, you can't terminate the contract. You have to keep going with it and you can only get damages. So with that out of the way, the next thing that we need to distinguish is what is a term, what is a right and obligation under the contract versus a non-contractual representation. And we'll hit that in the next video.